The EEOC's relationship with FEPAs has its origin in Title VII of the Civil Rights Act of 1964. The statutory charge deferral relationship with FEPAs has evolved over time with several court decisions that solidify various aspects of the deferral process. For example, in 1972, the U.S. Supreme Court upheld the validity of the EEOC's automatic filing procedure after the 60-day deferral period in Love v. Pullman. Congress amended Title VII through the Equal Employment Opportunity Act of 1972 to add the requirement that the EEOC give substantial weight to the findings of FEPAs in its own complaint processing. In 1980, the Supreme Court decision Mohasco Corp v. Silver upheld that the EEOC could not consider a charge filed on the initial receipt date, with proceedings only suspended during the 60-day deferral period to FEPAs. Today, through a more efficient dual filing process created under statutorily permissible work-sharing agreements, agencies are able to avoid charging parties losing federal rights by agreeing to provide the EEOC the right to initially process charges received by the FEPA 240 days or more after the date of the alleged discrimination. In 1982, in Kramer v. Chemical Construction Company, the Supreme Court stated that a charging party loses the right to litigate a Title VII claim in federal court if the claim is litigated in state court. As stated, the EEOC's contractual relationship with the FEPAs is based on Section 709B of Title VII, which permits the EEOC to cooperate with FEPAs, pay them for their assistance in Title VII enforcement, and enter into work-sharing agreements for charge processing. As with deferral, the EEOC's funding relationship with the FEPAs has evolved over time. The relationship began with a small research contract involving 11 FEPAs in 1966 for $165,000 with Wayne State University. In 1972, SLTP funding shifted to a focus on charge processing contracts to increase the level of FEPA processing. In 1978, responding to concerns expressed by civil rights groups and congressional oversight committees about inconsistency in its relationships with FEPAs, the EEOC created its first FEPA task force, made up of FEPA representatives and EEOC field and headquarters staff. In the same year, the EEOC convened its first annual EEOC FEPA conference to solicit input from FEPAs on improving the cooperative relationship. The task force recommendations gave priority to regularizing the funding relationship, including establishment of eligibility criteria, a per-charge payment system, charge processing standards, work-sharing agreements, and a quality certification system. The EEOC's response to the task force recommendations was the establishment of many program features and procedures that remain in place. The EEOC contracts with 91 FEPAs across the country.